Hi there, welcome to Help Solve the Case. Today we are talking about probable cause. I get questions from many of you on our cases about why did they make this arrest? Why did they do this? And I thought I would do my best to answer them for you using some examples from the Scott Peterson, Laci Peterson case. If you don't know me, my name's Christine Burke. I'm a retired police detective and sergeant. I am a current law enforcement policy, procedure, and culture expert, forensic genetic genealogist, and private investigator. And I love everything court. So let's get into it and let's start with what is the definition of probable cause? And I found here, I thought, who better than to explain it but the court? I was actually searching for Black's Law Dictionary, but this Texas court opinion came up and I thought we could read it. Let me zoom it in. It says, probable cause. Black's Law Dictionary states that probable cause, quote, ... amounts to more than mere suspicion, but less than evidence that would justify a conviction, end quote. So what is required is certainly less than proof beyond a reasonable doubt, clear and convincing evidence, or a preponderance of evidence. It is defined as, quote, a reasonable ground, not grounds, a reasonable ground to suspect that a person has committed or is committing a crime, or that a place contains specific items connected with the crime, end quote. And the reason that they're talking about the place is because you have to get probable cause for a search warrant. And they're continuing. These are the judges. Over 50 years ago, the Supreme Court elaborated on probable cause. In, I'm probably going to say this wrong, Brinegar v. U.S., the court stated that, quote, in dealing with probable cause, ... as the very name implies, we deal with probabilities. Here we get probabilities again, right? These are not technical. They are the factual and practical considerations of everyday life on which reasonable and prudent men, not legal technicians, act. Okay, and it says reasonable and prudent men, not legal technicians, act. So these are just reasonable people. It doesn't say reasonable police officers. It doesn't say highly trained technicians. It says reasonable and prudent men act. The standard of proof is accordingly correlative to what must be proved, end quote. The court noted that, quote, this means less than evidence which would justify condemnation or conviction, end quote. Instead, probable cause exists when the facts within the police officer's knowledge, where they had reasonably trustworthy information, are, quote, sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed, end quote. The court explained that, quote, because many situations which confront officers in the course of executing their duties are more or less ambiguous, room must be allowed for some mistakes on their part. The judge is saying that, not me. But the mistakes must be those of reasonable men acting on facts leading sensibly to their conclusions of probability, end quote. Okay? So it means that some reasonable men would think the same things. The court has reminded us since then that probable cause requires only a probability or substantial chance. That's an interesting word, right? A chance of criminal activity and not a prima facie showing of such activity. Is there a chance? So it's kind of like what I'm getting here. See, let me know if you get the same thing. Beyond a reasonable doubt is like, oh, I got this doubt here. I'm like 98, 99, but I just don't know about this one part. Okay. Here, the court says it's just a substantial chance. So it's like, is there a chance it could be true? Is it a chance what the police are saying? Like, does it make sense? Could it be true? If it could, right? So it's kind of like we got both ends of the spectrum there. It says other courts have further elaborated on the concept. The First Circuit notes that, quote, the probable cause standard does not require the officer's conclusion to be ironclad or even highly probable. There's the probability, those statistics again. Their conclusion that probable cause exists need only be reasonable, end quote. Right? And that sounds a little crazy because they're going to duke it out in court through the discovery process. And that's why the constitutional protections of the court are so important. And that's why I really like on this channel seeing who's going to step up and bring what game, what players they're going to bring, right? I talk about it, a sports analogy sometimes, football, basketball, first string, second string, who they're going to play, offense, defense, chess game, who they're going to bring to the table and how they are going to, for lack of a better term, duke it out constitutionally, right? These are litigators. The seventh, right? So it's not, it's about, it's like your ticket into the match, all right? Are these, and a bad analogy, but I'm trying to use it in a good analogy, the fight card. Are you going to be able to get on the fight card? All right. Do they have enough? Did you meet your weight qualification? You're going to get on the fight card. And then who knows what's going to happen? Okay. The Seventh Circuit has stated that, quote, in recognition of the endless scenarios confronting police officers in their daily regimen, courts evaluate probable cause not on the facts as an omniscient observer would perceive them, but on the facts as they would have appeared to a reasonable person in the position of the arresting officer, seeing what he saw, hearing what he heard. In practice, then, it can be said that probable cause, the area between bare suspicion and virtual certainty, describes not a point, but a zone within which reasonable mistakes will be excused, end quote. Do we like that? Do we like that? Reasonable mistakes will be excused? And our own Fifth Circuit, this is in Texas, has said that, quote, probable cause must be judged not with the logic of cold steel, but with a common sense view to the realities of everyday life, end quote. And I'm thinking about, in my mind, that mistake word with everyday life. If we look at as a reasonable person, not a cop, but as a reasonable person, do we get stuff wrong? Okay. It says, indeed, even when we have recognized that, quote, probable cause requires more than mere suspicion, but far less evidence than needed to support a conviction, or even that needed to support a finding by preponderance of the evidence, end quote. We have also recognized that, quote, reasonable inferences arising from the evidence may be considered in determining whether probable cause existed. With all this in mind, let us look at the facts, okay, set out in the majority opinion. Okay, we don't know that, all right? That is what the court said and talked about what the Supreme Court said. All right, now my assistant made some graphics here that hopefully we can talk about. Okay, now in talking about the Scott Peterson case, and we've just gone over that definition. What likely went into probable cause? Not every reported fact was part of the arrest decision. Probable cause is a lower standard than guilt beyond a reasonable doubt, right? We talked about that. So, according to Scott was the last person with Laci, last known person with Laci. Now, that could have been the phone call. There was that phone call the night before, or what Scott said. Scott said he went to Berkeley Marina, San Francisco Bay on December 24th. Laci and Connor were later recovered in the bay, linked to Scott's fishing trip. Okay, and that was some distance away. There was mention about Scott lying or concealing the affair. And is an affair, could some people consider that a motive for homicide? And then the police viewed some statements as suspicious or inconsistent. There were circumstantial timeline concerns. And the police believed that the facts reasonably pointed to Scott. And we talked about probable cause, enough facts to reasonably suspect a crime and make an arrest. Police do not have to prove guilt or eliminate every alternative. And that is important. What were the alternatives, right? When it went to trial, well, there was a burglary across the street. Remember, just to get on the fight card, maybe a bad analogy, but just to get in the door, they just had to have that probable cause. The fight, all the evidence is supposed to be exchanged with prosecution and defense pre-trial, discovery. It's called discovery. And that's things that the defense finds, and that's things that the prosecution finds. And prosecution is supposed to turn over everything, including exculpatory evidence. And the defense has the same mandate that if they find something, they have to turn it over. Okay? Their experts can be voir dire and things like that. They can be called to testify or questioned. So, what did we have? So, we have this burglary across the street that the police, whether it was the investigative team or not on Scott's case, the police in general knew about it. They did hear about van sightings, the burned van and the mattress. Again, I believe from the show, I did not follow the case, but from the show, I do believe that these investigators over here did know about a van sighting. They may not have known about the burned van and the mattress before they arrested, okay? They were aware, to my understanding, that there were witnesses who said Laci was seen after Scott left, but they may have dismissed that because of memory issues or mixing up the days, or they felt they didn't need it because they only needed a few things, all right? They had the dog scent evidence disputes, the fetal age science and the time of death disputes. Remember, and they may not have had the fetal age at the time they arrested him. They may or may not have had that. But then later, now we're finding out time of death disputes. They even had the lady from the show that we saw, the one expert testify arrange, and then they had the other guy come in and give a more concrete estimate. We hear now about destroyed or missing evidence, and now we have the marine supply notes. Did the cops look at that? Did they even test it? Did they do anything at probable cause? We don't know. And then there's the computer user attribution questions, okay? Okay. So we've got the house. Scott says he last saw Laci at home. We've got the dog running around without the leash. Remember, the neighbor with the leash without the owner. We've got Scott going fishing at the Berkeley Marina. Okay. Scott went to the warehouse. There was computer activity. Okay. The witness reports of seeing a pregnant woman walking the dog. There were reports of the suspicious van, and they chose only certain things of it, right? They took the Bay trip, okay, which turned out to be the body recovery locations, the affair and the false statements, the boat disposal theory about why did he buy the boat, behavior and timeline consistencies. In the show, they talked about, which was defense focused, that he didn't appear to be grieving as he should. They said that he was not cooperative, okay? And it was a circumstantial case, putting the pieces together, okay? They don't need to put the whole puzzle together. They only need a few pieces to match. Then the defense, the burglary across the street, the van sightings, the burned abandoned mattress, witnesses who saw Laci after Scott left, the dog scent, maybe being considered unreliable, the fetal age science, destroyed or missing evidence that the defense says that the prosecution didn't give them, the marine supply notes that could have been authored by Laci, and the computer user attribution questions. So, what did the police use for this? They didn't need everything. They only needed something that sounded reasonable. He was acting weird. Laci's missing. He bought this boat out of nowhere, right? The marine supplies and the anchor and all that stuff. He was having an affair. He didn't act right. And the fact that the house, that many times it's somebody close to home. And those are the pieces that they went with to make the arrest. Remember, it's a very small threshold. What did the court say again? A reasonable ground to suspect that a person has committed or is committing a crime. Seeing what he saw, hearing what he heard. Probable cause, the area between bare suspicion and virtual certainty, describes not a point but a zone within which reasonable mistakes will be excused. The court explained that because many situations which confront officers in the course of executing their duties are more or less ambiguous, room must be allowed for some mistakes on their part, but those mistakes must be of reasonable men acting on facts, leading sensibly to their conclusions of probability. Reasonable and prudent men, not legal technicians. So I don't know if that helps with that they don't have to connect all the dots. They just have to have reasonable dots, which sounds very scary. I'm having the image of at McDonald's or Burger King, whatever, that big, if you have kids, or I know you've probably seen it, that big play area with all those colored balls in the bottom and the kids just jump in. They don't have to connect all those balls. They only have to come up with one or two or three. And yes, they talk to each other and they say, what do you think? I think he had the boat and the boat was weird and he just bought the boat and he's not acting like we would expect him normally to be, and she's pregnant and she's going to have a kid and he's got this girlfriend and it's going to weigh him down for life. It just has to be enough that somebody would be like, yeah, I got you. Now, it does have to go into court and it does have to stand up to that, but that's for the court and the jury to decide. That is when everybody pulls out all of their stuff. So in the beginning, they only need a few dots connected. They only need a few of those balls. They don't have to collect every ball in that playpen thing. They don't have to collect all of those. So, yes, did we have the van across the street? Yes. Was there a date discrepancy between the 24th and the 26th? Yes. Did people report seeing different things? Yes. The court talked about reliability. Did they believe one was more reliable than the other? They had the dog that hit in the marina, right or wrong with the slipper or whatever was going on with that. They had the dog that hit in the marina, okay, which to them said he was here. He only said, I was fishing, okay? So I don't know if that explains that. Talking about connecting the dots in probable cause. We recently saw the case of Dr. Samuel Lee, and you were asking about that. So I was going to try to lay that out about how that probable cause is articulated against the elements of the crime. We talked a little bit about it in the Tyler Robinson case with Charlie Kirk, because some of those elements, some of those crimes charged have various subsections, right? Homicide is pretty much intentional or not intentional. And then you can have weapon enhancements or victimology enhancements like the hate crime and things like that. So not not debating the seriousness of it all, but you have a deceased person and it was caused by someone else, right? So it's either manslaughter or intentional. And then how did they do it? So just to illustrate that they just need to do enough, right? Going back to the fight card thing, people can talk about how great they are and how bad, bad blank, bad donkey, a fighter they are, and they can make their weight class and get on the card, but they've got to prove themselves in the ring, right? People can talk all the time. So the police can say, this is my theory. I believe this is what's happened, and here's why. Boat, house, dog, da da da. But the true, when you're getting punched at and when you have to jockey around and move around, is in court. You've got the Constitution, and maybe the Constitution is the referee, if we're using this analogy, right? You got the referee calling you out on can't do this, can't do that, you have to do this right. Okay, fight fair. And then the defense is coming to knock you out. And maybe you're going to try a new move, right? After the arrest or indictment, whatever happens, the prosecution may continue to build their case, right? They may use new tricks or new fighting techniques that they didn't use in previous fights. Okay. And then the defense is coming and they are bringing everything that they have. They're bringing all this new evidence. And so if we think about the evidence as fight moves, it has to stand up in court. It has to stand up in the ring. And then we get the score, we get the jury. Yes, no, knockouts, technical knockouts. Okay. Was he down or was he not down? Get up, get up. How long? How many punches did you pull? How many, right? That's just, I think, let me know, a good analogy about how it goes. So we don't see the fight before the fight. We see it in court. And you just have to get on the fight card meeting the elements of the crime, which is, it is probable cause, but it's a little bit different. So hopefully that makes a little sense for you. It's a reasonable person. Cherry picking popped into my head because I think we heard about cherry picking the scent dogs, but cherry picking. So one officer has to write the probable cause affidavit. And the officer says, the officer is the reasonable man or woman saying, this is what I think happened, and this is why it constitutes a crime, and I'm arresting the person, or I'm asking for a warrant to come down to arrest the person. That's the fight card. Then you got to weigh in. They got to make their weight. So they go before the judge in the probable cause hearing. And sometimes they discuss it, sometimes they don't, sometimes they just get the indictment. And then that's it. And then the big guns, and the fighting techniques and all that stuff comes out during the trial or during the bout. And then the judges decide, the judge or the jury, who are the judges, okay? The triers of fact, or the trier of fact, all right? So let me know if that makes sense. Hopefully it does. I will see you on the next one.